Welcome to Bloomberg Law. I'm Pacchia. The Consumer Financial Protection Bureau was created when Dodd-Frank was signed into law last year. It has been called the nation's top cop for policing the financial services industry. Next month, the Bureau will assume its full powers. Joining me now to discuss is Rori Cassirer. She's the managing partner of Troutman Sanders' Manhattan office. Rori, welcome to the program.
Thanks, Lee.
Thank you for coming in.
My pleasure.
So the Bureau comes online mid-July.
July 21st, right.
That's only a couple weeks away, but we don't have a nominee in place to run the Bureau. They can start some of their work July 21st, but how much can they get done before a nominee can make it through the Senate nomination process?
Well, in reality, they can get most of their job done because the Secretary of the Treasury is in charge of the Bureau in the interim before an actual director is appointed. Mm-hmm. So at this point, they've got Elizabeth Warren being a special advisor to the Secretary of the Treasury. And frankly, on July 21st, when the Bureau comes online, they can do everything except the non-banking mandate that they have. So, for example, they can work into Goldman Sachs or Bank of America or any other banking institution and do whatever they're supposed to be doing. But they can't deal with mortgage brokers, they can't deal with payday lenders, they can't deal with any non-bank institutions till there's an actual director in place.
Right, so it sounds like they can do a lot, and the nomination might be a little bit of a political red herring at this point. That said, I would love to know your thoughts. Who do you think is going to actually get the nomination and make it through the whole process to the other side?
As long as you don't attribute my thoughts to anything official, I mean, I would say that it's probably Elizabeth Warren, as controversial as she's been. The reality is that she sort of got this thing up and running. She's the one who's put a lot of the works into play. She's hired people. They've got a staff, including senior staff. I could be wrong,
right. It's
but
her baby
but
at this
I
point.
think
She's certainly the most qualified to continue to work with it.
Well, it's her baby, and whether I share the opinion that she's the most qualified or not, and I actually do think she's terrific at what she's doing, but. The problem is not Elizabeth Warren. I think the problem that the Republicans or I would say the opponents of this Bureau see is the fact that it's perceived to have too much power without as much oversight as they would like it to have.
Well, let's talk about that power for a moment. What's the ultimate effect of this Bureau going to be on the marketplace? How is this going to play out when we get to the other side of the nomination process?
I think the jury's still out on that one. I think it's a little too soon to tell. One thing that I believe there's consensus on is that it'll be a lot more expensive to be in business. You're going to have banks and other financial institutions will have to ramp up compliance. Mm-hmm. I think they're going to have to hire people, make sure that all the T's are crossed and the I's are dotted, and make sure that all of these regs, and there's about 18 statutes that the Bureau is taking oversight of. Mm. And hopefully they'll get the compliance people into place. In terms of transparency for the consumer, we'll see. I don't know, but I can tell you that I think that the consensus among the banks and other people, as well as consumers, is that they've gotten off to a good start, for example, and they're simplifying the RESPA and Truth in Lending forms, which no one ever understood. So I think they've got some simplified form. It's a 3-page or 4-page form. It's out on the website. People are commenting on it. That's something that's actually gotten a lot of praise. So if they're going to do that with other regs that they approach and with their other rulemaking, I think it'll be okay on that part. But again, it's going to be expensive.
It's been interesting in doing research for this story. There's been a lot of emphasis on CFPB's enforcement capabilities. Richard Cordray, the former Attorney General from Ohio, is heading up that wing of the Bureau. How soon after July 21st do you expect them to file a lawsuit?
July 22nd.
To be quick.
I don't know if it'll be them or if it'll be the state attorney generals filing it on their behalf.
It certainly seems as if they're posturing an aggressive stance.
I think that's the way the law is set up, so that they work in tandem with the state attorney generals. They're going to have a lot more power than they had now. They're going to sue on behalf of the CFPB as well as themselves. I think they've actually taken some very aggressive positions. I'm aware of one lawsuit right now where there are certain collection agencies which have been trying to settle a class action in Ohio. And the state attorney generals are trying to stop it because they say it'll gut what their job is when they come on board in July.
We were talking before about how the Bureau is working in tandem with state attorney generals in negotiations related to fraudulent practices and foreclosures.
Correct.
How is that going to work? Who leads when those two start to dance?
Well, that's unclear.
That must be a fascinating dynamic behind closed doors.
You know what? I think it is, and I think it's one that'll evolve. I assume that they'll cut a deal where they lead on one set of actions and the CFPB leads on another set. I mean, that's what I would do if I were them.
So the immediate impact, it's the banking sector. They're most concerned about this Bureau coming online. Putting ourselves into the shoes of the banks, how is this going to work? What's the process look like when they start to deal with the Bureau?
I would hire someone who knows some of the people who come out of the agencies, because the Bureau itself is hiring people from the agencies, including the Trade Commission and others. And I would be very proactive in either having people inside or outside knowing these regs inside out. And actually, since the Bureau is soliciting comments on things, I would have people ready on the ground giving them the comments as they affect my institution.
And what about non-banking firms that might fall under the purview? How are they going to be affected by whatever comes to bear on the 21st?
Well, I don't know that any of them will be affected immediately. But, for example, I know that they're looking at the credit reporting agencies.
Right.
There are some regs that are out for comment that came out on May 31st. Nothing really earth-shattering, but it shows that the agency's thinking, that the Bureau is thinking about that. They're going to have to make sure that they're accountable for their credit reporting and that they can deal with any mistakes within 30 days of those mistakes happening. I mean, I can see a lot of litigation in that area where if they make a mistake and they don't correct it in time, they're in trouble. Also, since there's going to be a lot more transparency in terms of consumers being entitled to see their records, and being entitled, more importantly, to see the basis for their records for the analysis, for example, of why credit is costing them more, that they're a risky credit. I can see a lot more litigation, consumer litigation arising out of that one.
When we've talked about various aspects of Dodd-Frank on this program, we've found a lot of criticism about the way the government has structured whatever process is emanating out of a particular area of the law. What's your analysis on this Bureau? Did the government get this right? And if not, what could they have done better?
I think that, as with any other expansion of government regulatory power, you run the risk, and it depends on how it's implemented, of them throwing out the baby with the bathwater. And there may be too much regulatory bureaucracy. There may be too much reporting. There's a risk of privacy breaches because there's transparency in the form of both FOIA requests as well as consumers accessing their information. And then once consumers complain, other people can access that consumer's information. I think that I'm not sure they've gotten it right. Let me put it that way to answer your question directly. I think they're going to have to tweak it based on experience. Assuming that we're all acting in good faith, that'll happen. I mean, just kind of the pendulum swings all the way across and then it swings back as experience shows that it doesn't work.
Net, will this improve protections for consumers?
I don't think the law itself will improve protections for consumers. I think the way it's enforced may do so, depending on how the enforcement works. I think all these laws were in place. There's very little new under the sun. It's just that all of a sudden they've been consolidated into one place.
For enforcement.
Yeah, they've been consolidated in one place. We'll see whether this Bureau and the AGs together accomplish the job that hasn't been done before.
Rori, thank you.
Thank you.
That's Rori Cassirer. She's the managing partner of Troutman Sanders' office here in New York. If you'd like to learn more about the cases or issues we just discussed, go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. I'm Pacchia. Thanks for watching.